Okay, I think we can start. And thanks everyone for being here. And this is the first appointment of the Fairness, Accountability, Transparency and Ethics initiative that we are starting today. And for the next 5 weeks, we will have the possibility to listen to 5 researchers, which are the ones there, who will talk about how machine intelligence, autonomous system, and in general AI, let's say, it's already impacting or can impact our daily life and can have social implication. So we have thought to organize this series of seminars for understanding who in the UPF community is interested in these topics, which is quite a wide range of topics, but considering the multidisciplinarity of our department and our university, we thought that it can be good to have a meeting place and to debate and to think about issues, not just specific to our topics, let's say. And the session will be more or less a first part with an introductory lecture, and then a short hands-on session where we will discuss and debate about real cases. And today we start with Francesca Lagioia, who will introduce the topic about automation of personal data and consumer law enforcement using AI. So thanks for being here.
Thank you very much. So, hello everyone. Thank you for inviting me. First of all, I'm very happy to be here. I'm actually a researcher at the University of Bologna and at the European University Institute, and I'm working in the artificial intelligence and law domain since the beginning of my PhD. That was in law, science and technologies. And my presentation today concerns the possibility of using AI for enforcing both the general data protection regulation and more in generally the privacy law and also the consumer's law. In particular, I will focus on Claudette, that is a system developed at the UI under a project, a European project financed by the European Research Council for Funding and the Brussels Consumer Association. It's more or less, and here you can see some of the members of our team. It's an interdisciplinary team. It's coordinated by Professor Mikritz and Professor Giovanni Sartor. There are 2 computer scientists coming from the University of Bologna and the University of Modena and Reggio Emilia that are Paolo Torroni and Marco Lippi. So the context is provided by, of course, the widespread adoption of AI in the business sector and the big data era. This is one of my favorite from 1984 by Orwell. If you want to keep a secret, you must also hide it from yourself. Why? Why it is relevant? Is there a big brother watching us? So the idea is that nowadays we do reveal much more information about ourselves online than before. And those information are collected by organizations and businesses which are gaining advantages by employing AI, the massive analysis of those information. Just think to what we share every day on social networks. The problem is that there are also some complex trade-offs that are coming from giving away our privacy, since every personal information can become a sensitive information. So this is why recently AI is perceived as something at the service of business and as a threat. It is currently affecting consumers in different areas. For example, with regard to their privacy, their autonomy, economic interests, their behavior, or, for example, to the possibility of accessing goods and services. Just think to the possibility of accessing loan, for example, or the possibility that, for instance, analyzing certain data, it is possible to target at the advertisement and influence the consumer's behavior on the market. It quite frequently happens that, for example, you decide to buy something that you really don't need only because you were targeted and, for example, businesses are sending you some specific kind of advertisement. So we think that this should not be the case, and that the AI can be used also for empower consumers.
But don't you think the consumer has a choice in actually accepting it or rejecting the targeted advertisement?
It depends. It's not always the case. So there are many studies, for example, in social sciences, psychologists, but also, for example, by people coming from the economic domains, that shows basically that the behavior is influenced by, for example, the targeting advertising. And this is why, for example, the General Data Protection that came in force on the 24th of May of 2019 states that, for example, the targeting advertising can be done only with the consent, for example, of consumers. But also just think to the possibility, for example, of, let's say, the automatic thinking. So actually, there are a lot of systems that decide whether or not, for example, you can access to loan, analyzing your data that you usually share on social network, also because businesses are sharing data among them.
What would you categorize AI under? Would it be automated or would it be controlled by somebody?
What do you mean?
Like AI, artificial intelligence, if I actually think about it, it just means a machine that can think for itself?
Okay, this is a very complex question, whether or not a machine can think by itself. As you probably know, there are a lot of definition of AI and also a lot of definition of intelligence. So it's not so easy to, we can debate if you want, but it's not so easy to give you a clear definition about that. But for sure, there are some processes that are actually automated, and there is an algorithm and there is a machine that basically decide whether or not, for example, there is the risk of recidivism. And this is something we were talking before starting the lecture. There is a quite famous that is used in the United States, but as far as I know, also here you have a quite similar, for example, system. And that can be used, for example, by judges to decide, for example, how many years you should be in jail. So it's something that really can affect, for example, taking into account data like, for instance, I don't know, race or, for example, the geographical area in the city where you lived and so on. So there are a lot of information that can be used for influencing, for example, both the consumers' behaviors, but also, for example, the decisions of organizations and administrations in regard to consumers. So the question is, how can we empower consumers? So one possibility is through the law, and for instance, here we have the General Data Protection Regulation that is in force for protecting, for example, consumers for unwanted monitoring activities. But also we can support consumers, for example, in detecting unfair practices, and we will see how, but also in controlling commercial practice fairness. So this is a quite famous statement by Ken Galbraith, where the idea is that an opposing exercise of power is the principal solvent of economic power, the basic defense against its exercise in economic affairs. So the idea is that in the big data era, in the AI era, if we really want to protect consumers, we should use AI, the same means, to protect them. And so we come up with the idea of Claudette. It started, as I told you, 1 year ago, more or less. And it aims at automatically detect potentially unfair clauses, both in terms of service, that are consumer contracts of online platforms, and privacy policies. Why? Because usually consumers agree but don't read. I'm quite sure that whenever you, for example, download an app from the App Store, you usually click on accept, but you don't know what you are exactly accepting. NGOs, like, for example, consumers' organizations, have competence to control, but they lack the resources for control in terms of both, for example, personnel, but also time. Just think to the large amount of services that we are using every day. And business, despite legislation in force, such as the Consumers Directive, the Unfair Terms Directive, and the General Data Protection Regulation, business keeps using unlawful and unfair clauses in their privacy policy and terms of services. So we started with in training the system, collecting some terms of services. At the very beginning, the dataset contained 50 terms of services that were selected among the big players, taking into account the relevance in terms of users, for example, but also the geographic usage and so on. And we started, now they are more than 100, and we started to manually to analyze those documents and manually tagging in XML such document to train the system. So in order to analyze the clauses contained in the contract, we started with the Unfair Contract Terms Directive, which states that a contractual which has not been individually negotiated should be regarded as unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations arising under the contract, to the detriment of the consumer. So the idea is that there are some clauses that can be used by businesses and that cannot be present in contracts. So we started, we identified at the very beginning 9 different categories of clauses, of unfair clauses, that you can see in this table. And for each category, assume that they can be clearly fair, potentially unfair, fair. Why potentially unfair? Because of course there are clauses that are always unlawful and unfair, while there is also the possibility that if you read the specific clause in the context, the clause become, let's say, fair, depending on all the context of the contract. So for example, the arbitration clauses, the unilateral change clauses, which, for example, states, now we will go more in depth in some of these categories. But for example, the unilateral change clauses pertains the possibility of unilaterally change the terms of the contract by the businesses. For example, the price, just to give you an idea. Content removal, the possibility for the provider of removing part of your contact that you, for example, have, I don't know, on Dropbox or whatever. Jurisdiction clauses, choice of law, the limitation of liability, the possibility to unilaterally terminate the contract. This is a quite famous clause, contract by using. So it's frequently that at the very beginning of a contract, you can find a clause stating, for example, simply by using the service or visiting the terms of. And then the last one, that is the privacy included. I will go more in depth. This is a clause, this is a category that we added only after the GDPR entered in force, since it creates, in a certain, I would say, a link between the terms of services and privacy policy. This is because basically the idea is that the consent should be given in a freely way, so you cannot, for example, infer the consent, for instance, simply by visiting a website for the processing of your data. And we will see better in a couple of minutes what does it mean. Example of a contract marked with the XML tag. So as you can see, for example, the first one, potentially unfair liability clause. The number 2 is appended to the symbol. As you can see in this table, in the second column, we have the symbol that we use for marking the document. In the third one, with regard to the data set containing 50 terms of services, the number of clauses, of unfair clauses for each category that we found in this document. And then, once again, for each type of clause, the number of documents containing the unfair clauses. So let us try to better understand what we are talking about. With regard to the jurisdiction clauses, for instance, the question is, where a dispute will be adjudicated. According to the European law, consumers have the right to go in the court of their place of residence. So, for instance, if you want to go in court against, let's say, I don't know, Ryanair, you have the right to go in court here in Barcelona. You do not have to go, for example, in whatever, San Francisco, California, or in another place. So, in this regard, if a clause gives consumers a right to bring disputes in their place of residence, then the clause has been marked as clearly fair. If stating that any judicial proceedings takes a residence away, namely in a different city, in a different country, and so on, the clause has been marked as clearly unfair. To give you this clause taken from the Dropbox terms of service, which states that you and Dropbox agree that any judicial proceeding to resolve claims relating to these terms or the services will be brought in the federal or state courts of San Francisco County, California, subject to the mandatory arbitration provision below. Both you and Dropbox consent to venue and personal jurisdiction in such courts. So what do you think? If you have some troubles with Dropbox, would you go in San Francisco? Maybe not. So this is why, yeah, I can imagine. Okay, this is about the limitation of liability clauses. Here the question is, for instance, for what actions, events the provider claims they will not be liable. So if the clause states that the provider may be liable, the clause has been marked as clearly fair. If the clause states that the provider will never be liable for any action taken by other people, damages incurred by the computer because of malware, when contains a blanket phrase like to the fullest extent permissible by law, then the clause has been marked as potentially unfair. When the clause states that that the provider will never be liable, for instance, physical injuries, gross negligence, or intentional damages, then the clause has been marked as clearly unfair. Okay, so here you have an example taken from World of Warcraft. This is a clearly fair clause, liability clause, since it states that the provider is liable in accordance with statutory law in case of intentional breach, in case of gross negligence for damages arising as a result of any injury to life, limb, or health, or under any applicable product liability. So this has been marked as one is for clearly fair. The second one is taken from 9gag and is a potentially unfair clause since it states that you agree that neither 9gag Inc. nor the site will be liable in any event to you or any other party for any suspension, modification, discontinuance, or lack of availability of the site, the service, your subscriber content, or other content. So this is a potentially unfair clause. And this one, the last example, is taken from the Rovio terms of service. It's a clearly unfair clause since it's in no event will the provider's affiliates, licensors, or channel partners be liable for special, incidental, or consequential damages resulting from possession, access, use, or malfunction of the Rovio services, including but not limited to damages to property, loss of goodwill, computer failure or malfunction, and to the extent permitted by law, damages for personal injuries, property damage, lost profits, or punitive damages from, basically they are not liable for anything. Please.
All these clauses, the fair and unfair ones, I guess they are all legal, nonetheless.
They are only?
They are all legal, they are allowed to present this clause?
The unfair clauses, no. They should be considered as invalid, basically. So if there is a clause like this one, but the idea is that, for example, if you are not a lawyer, you read, for example, this clause, if you have trouble, you will not go in court. You will not ask, for example, for damages, restitution.
Okay, so almost all the clauses that you mark as clearly unfair, they are not, in principle, they should not be allowed to say that.
Exactly. They are not allowed.
But this is a matter of European regulations for American companies, or is this in general? Like, for instance, in the case of Dropbox, they're an American company?
But this does not matter because, for example, also with regard to the general data protection regulation, the idea is that, for example, you can have a different legislation for American people, but if you are offering your service to European citizens, then the European law applies.
So it's always the local law that applies, right?
Yes, exactly, depending on where you are resident.
Is it applied to the European citizens who stay outside of Europe as well?
Yes.
Or people stay in Europe as well?
No, if you are a resident in the European Union. So if you are a European citizen, so let's say that if you, for example, move your domicile for a certain period, you are still considered under the European law a European citizen.
And the other way around, if the non-Europeans live in Europe, if a non-European person resides in Europe,
Then the European law applies. So let us move to this other category, that is the privacy included. So here the idea is that under the GDPR, if someone wants to process your data, there are many different possibilities, many different legal bases on which the processing can be done. For example, one possibility is that the processing is needed for the performance of the contract. Just think for to services like booking. So if booking have to make a reservation in an hotel for you, they need for sure to process some of your data for making the reservation. But there are also some other legal bases. So for example, if the legal basis is the performance of the contract, you don't need the consent of the consumer. One other possible legal basis is the consent of the consumer. But in this case, the consent, as I told you before, should be given freely and should be given with, let's say, cannot be inferred. So the idea is that after the GDPR, most of the businesses started in putting this kind of clauses, which usually state, for example, that the consumer to the privacy policy simply by using the service. So all those kind of clauses are potentially unfair. Here there is an example taken from Evernote, which states that by using the service, you acknowledge, accept, and agree with all provisions of the privacy policy, and moreover, this clause is in the contracts, in the terms of services, and not in the privacy policy, including without limitation the use and treatment of the text, images, and other data you choose to input, upload, or store in Evernote, and your personal information in accordance with such privacy policy. Here there is another example. So it is taken from the DeviantArt terms of services. So you have two clauses that read in combination become unfair. The first one states that by using our service, you agree to be bound by section provisions applicable to all users of our service, including visitors to the DeviantArt website. As I told you at the beginning, according to the Consumers Directive, a clause is considered unfair whenever it is not individually negotiated. So a consent by using clause, of course, is not negotiated with each consumer. And then you have another clause stating that the terms of DeviantArt's privacy policy are incorporated into and form a part of these terms. So basically, the idea is that simply by using the service, you agree to the processing of all your data, and also you agree to be bound to the terms of service. Okay, so we collected all these documents for creating the dataset and train the system. From a machine learning point of view, we modeled the problem as, first of all, a detection task. So the question is, does a sentence contain a potentially unfair clause? The answer is positive if P is unfair, is negative otherwise. And then we modeled the problem as a sentence classification task. So the question is, what is the category the unfair clause? We test different possible approaches, including the three main approaches where the backwards, the tree kernels, and the use of convolutional neural networks. We adopted the so-called leave one out procedure. So each document in the dataset in turn is used as a test set, leaving the remaining documents for training the system, and validation set for the model selection. We use three metrics. I'm quite sure that most of you are computer scientists. Please apologize if this is something, but usually I do seminar with lawyers that do not have any idea of what I'm talking about. In any case, the precision, the recall, and the harmonic mean between precision and recall. And for the comparison baselines, we used random, of course, detection, and we considered the clauses as always positive. Here you can see the results, the performance on the training set of 50 terms of services. As I told you, now we have, the data set has been increased. We have more than 100 documents. And the best performing system is an ensemble of support vector machines and convolutional neural networks, as you can see here. And in this table, you can see the data for each of the category that I mentioned before, with the exceptions of the privacy included, since it has been also with regard to this category. So the system correctly detected around the 80% of the potentially unfair clauses in each category, ranging from a minimum of the 72% with regard to arbitration clauses and up to the 89% as in case of the jurisdiction clauses. Actually, we have a prototype. It's a research prototype, of course. It is online and is free to use. If you want to test it, you can do it visiting our website. So basically, you can simply paste the text of a contract, and after some minutes, the results of the system assessment appears. And pointing on the clauses that are highlighted by the system as potentially unfair, you can see the category to which they belong to. Then we decide, as I told you, to move on and also in training the system with the privacy policies under the general data protection regulations. So here we defined a golden standard, what we call the golden standard, on the basis of some of the principles stated in the general data protection regulation that are the lawfulness, the fairness, and transparency principles. In this regard, we defined the three main dimensions. The first one is clarity of expression. So the idea is that the policy should be framed in an understandable and precise language, so that, for example, consumers that are no lawyers clearly understand what is written in the privacy policy. The second one is the comprehensiveness of information. So the policy should contain all the information required by the GDPR, and we will see some of them. And the third one is the substantive compliance. So the policy should only allow for processing of personal data that are compliant with the law. For each of those dimensions, we defined, as we did with the terms of services, different possible levels of achievement of the golden standard, optimal and suboptimal, and sometimes also questionable or insufficient under the suboptimal dimension. So here, as you can see, from the machine learning point of view is a little bit different, because with regard to the substantive compliance, more or less it's the same. So the idea is that the system should be able to recognize whether a clause is fair or unfair. With regard to the comprehensiveness of information, the system should be able to detect whether all the required information are in the text or whether they are missing, or whether, for example, there are only partial information. So under the second dimension, under the comprehensiveness of information dimension, as you can see here, we define 23 categories. Those are only some examples. According to the GDPR, the provider should give to the consumers information about the identity of the data controller, the contact details of the data protection officer, should specify the purposes of the processing, the legal basis for processing, like, for example, the performance of the contract or the consent, and so on, as I told you before. The categories of concerned. So, for example, with regard to the categories of personal data and the purposes of the processing, there is a principle in the GDPR that is the minimization principle, which states that basically businesses should collect and process only the information that are needed for the specific purposes. So the idea is that in the privacy policy, The provider should specify what are the information collected, and for each information, what is the purpose, the specific purpose of processing. So just to give you some example, with regard to the purposes of processing for which the personal data are intended, where the clause states that the purposes of where the purpose of processing is exhaustive and not vague in the clause as a fully informative clause. In any other case, for example, when a clause only provides examples, it has been marked as insufficiently informative. This is an example taken from the WhatsApp privacy policy, and it states that WhatsApp must receive or collect some information to operate, provide, improve, understand, customize, support, and market our services, including when you install, access, or use our services. What's the meaning of this clause? What's wrong? Basically, they can do whatever they want. They can do everything. What does it mean exactly improve the service? What does it mean, for example, customize?
But aren't they allowed to do that under the GDPR? Because businesses can access and use your data for purposes other than what they've collected?
This is something that should not be done under the GDPR. So this is why, for example, we are working with consumers organizations that co-financed, for instance, our project, because the idea is that given the large amount of documents that should be analyzed by humans, it's impossible, basically, to deal with these kind of issues. And so the system should not completely replace human lawyers, but at least it could improve, let's say, the scanning of documents. So with regard, with regard, for instance, to the categories of personal data concerns, clauses where the categories of personal data are comprehensively specified and not vague, and in all the other cases as insufficiently informative. For example, when they only provide examples. This is a clause taken from the Google privacy policies that has been updated after that the GDPR entered in force, and states that we collect information about your location when you use our service, which help us offer features like deriving directions for your weekend getaway or short times for movies playing near you. What do you think? What's wrong with this clause? What does it mean, information about your location, and why? It's the Google privacy policy. So if I'm Googling something, they are collecting my location. And more precisely, what kind of location they are collecting? Do you think that this is fair or unfair? It's quite specified or not?
Not very specific, because depending on the apps that you're using, maybe if you're using the location apps of Google, then maybe it would be okay to, process my location data, otherwise not.
Any other idea? So I can say in this case that your trade-off is higher than ours because we mark this clause as fair, basically because at least they are specifying the kind of information that they are collecting, that are location information.
But in this case, they are not limiting the use that they can do.
Not in the same clause, but of course, so first of all, I forgot to tell you that some clauses can be marked under different possible categories. So the idea is that, for example, the tag can be nested. But of course, you have to analyze the whole contract or the whole privacy policies, and it is possible that, for example, you can have that the provider, for instance, specifies why they are using those information in a different clause. So this is the idea. Okay, let us move to the eDream clause. If you sign up for our website using your social media account, link your account on our website to your social media account, or use certain other social media features of ours, we may access information about you via that social media provider in accordance with the provider's policies. What do you think about this clause?
They don't say what information and why they need it.
Exactly. They are collecting, they can collect whatever they want. So if you access, for example, to eDreams with, I don't know, your Facebook account, your LinkedIn account, or whatever, they are collecting all the information that you have in your profile. And we don't know what other information, for example, since the clause states that in accordance with the provider's policies, so for example with the Facebook policies, what kind of information Facebook is sharing with other businesses.
But if you access with, for instance, with your Gmail account, then they have access to the email?
Okay, so the email should be protected, even though there are some recent cases where basically the password was not encrypted, and there was a scandal, quite famous scandal in this regard, for instance, not with Gmail, with another provider. But in any case, no, the idea is that, so, you know, they can write whatever they want in the contracts and privacy policy, and we don't know what they actually are doing with your data. So for instance, when WhatsApp has been sold to Facebook, if I remember well, recently the old CEO of WhatsApp made a declaration, an interview, stating that he was very sorry for selling WhatsApp to Facebook. Why? Because basically they are collecting all this kind of data, starting from the social network, your phone number, and so on. So we cannot know what they are doing, but we can monitor what they state, at least. And as I told you, despite legislation in force, they still keep using unfair and unlawful clauses in their terms and conditions and privacy policies. Okay, so here there are the categories of clauses that we identified under the substantive compliance. So also here there are some categories that are quite similar to those of the terms of service, like policy change. For example, the possibility for the provider to unilaterally change the privacy policies, and the possibility, for example, of stating something like, we do not notice you the changes, so we will post them online, and you have the barn to go online and check whenever we are changing our privacy policies, for instance. And also, for example, the consent by using, and so on. So this is an example of clauses related to the policy change. So when the notice is given to the consumer and the new consent is required, the clause has been marked as fair processing clause. When the notice is given but the new consent or the confirmation of reading is not required, then the clause has been marked as problematic. So this is an example taken from Twitter. We may revise this privacy policy from time to time. The most current version of the policy will govern our processing of your personal data and will always be at twitter.com/privacy. If we make a change to this policy that in our sole discretion is material, we will notify you via a Twitter update or email to the email address associated with your account. What's wrong with this clause? So if they change their privacy policy, let's say that in the privacy policy they decide to state that, for example, they can collect your, I don't know, sensitive data regarding the health status or something like that. You will never know. With the exceptions, if you decide, I don't know, each week you will go on the website for checking whether they have updated their privacy policy.
And you signed it already?
Yes.
You sign it and then it will be changed, doesn't then
Exactly.
something is changed that you didn't sign?
Yeah, yeah,
So
it's true.
every time it would be updated, there would be the need for a new consent of the user. I don't
If
know
the legal
anything
basis,
about
yes,
but
this is the idea. Yeah, exactly.
that would make sense.
We might amend the privacy statement from time to time. If you care about your privacy, visit this page regularly and you will know exactly where you stand. This is amazing. This is the book taken from the book in privacy policies. Okay, and finally, with regard to the clarity of expression, so basically we identified some indicators of vagueness. For example, the use of conditional verbs, conditional terms like depending, as necessary, from time to time, and so on. Generalizations, so when we, for example, state, usually we process your data for this purpose. What does it mean, usually? generally, we process your data for this purpose. What does it mean? Then also the use of modality. For example, we might process your data for, I don't know, targeting advertising. What does it mean, we might? Are you processing this data for advertising purposes or not? And also the non-numeric quantifiers, such as, for example, certain, some, many, including. For instance, consider a clause stating that we process your personal information, including your name, surname. What does it mean, including? So it's not exhaustive, it's an open clause. This is an example of an extremely vague clause stating that we generally may share personal information we collect with certain service providers, some of whom may use information for their own purposes as necessary. So basically, this clause allows the provider to do whatever they want. Okay, we started in training the system with 14 documents. Now the dataset has been increased. We do not have a prototype online. We only have a prototype for the detection of vague clauses, since the dataset is very small, and now we have 32 documents. We are still training the system. We have also a web crawler that has been developed as a tool for the automatic privacy policy monitoring. So there are two types of monitoring: checking the data of the document and then compare the document with the document in the dataset to see whether or not, for example, it has been changed. And then also for earnings reports by email to, for example, the data protection organization, also to us, to know whether, for example, a privacy policy has been changed. So in the near future, of course, we would like to extend our project in different directions. First of all, we would start to analyze errors, for example, that can be fixed by a rule-based model, adding a rule-based model to the system, for instance, for dealing with exceptions. It's quite frequently that, for example, you have a clause that is unfair, for example, a jurisdiction clause stating that, for example, the competent court is San Francisco, California, and then you have another subsequent clause right to go in court in your place of residence. So actually we are not able to deal with this kind of exceptions, and this is why we are thinking to the possibility of adding a rule-based model. We are working with Prolog now for this kind of issues. Then, of course, expanding the corpus, especially the corpus of privacy policies. We would like to be able to have the system working also in other languages, and we started with German with, I would say, quite good results. And then also the possibility of providing the explanations. So the system should be able to provide explanation and also, for example, arguments in favor of explaining why a clause has been marked as potentially unfair, possibly also referring to, for example, the law or the article of the law. So here you can find some publications if you're interested to go and you want to go more in depth in what we have done so far. And thank you very much. I'm done. I don't know whether you have questions.
There are any questions?
Please.
So if I want to start an evil business in Europe, probably the first thing I'll think is try to do the adversarial attack towards the network. And this adversarial attack can be very critical to these kind of legal issues. And like, do you have any opinion or like preparation against this?
I mean, I don't know what to say. It is true, but you know, I think that we are always in late, in the sense that, especially from the legal point of view, you know, AI and new technologies are developed, and so far what we are trying to do is basically to, I would say, fix all the problems and issues. So I don't know, for example, also with regard to Claudette, just to give you an idea, we know that there are some businesses that are checking, for example, their contracts using Claudette to see how, for example, to find a way, basically, for, how do you say it in English? Ingannare. Could you help me? So yeah, exactly, thank you. Yeah, so I do not have an answer, an exhaustive answer on this, but for sure it's something we should think about.
So the businesses that have these unfair practices, what do you want to do about them? Is there already a market?
So the idea is that, for example, working with consumers organizations, so you can think to the system in different ways. So actually it's a very preliminary prototype. But the idea is that, for example, you can have an app in the near future, and whenever, for example, you download, I don't know, a service, so there is a pop-up saying, hey, you know, you are agreeing on, I don't know, this clause, and this clause is unlawful, and for example, it can also help consumer for, I don't know, collective actions against, for example, businesses, against Facebook and so on. But also, for example, can be used by, as I told you, consumers organizations that are lacking the resources and the capacity to control, but have the power for controlling, so, and for going in court. So this is the idea.
There's been a lot of talk recently about fairness in artificial intelligence, fairness in machine learning. So you're using a machine learning system to determine whether
exactly.
these clauses are fair.
Yeah.
Have you done any work into making sure that your systems are fair in the way that are marking clauses as problematic?
What do you mean? If the
if
data set is biased, or?
Right, so if I paste a terms of service into
we are not collecting information,
sure.
Actually.
But if it says clause 6 is unfair because of this reason, but that's not true, then your system is giving incorrect answers.
Yes, this is true. It could give you an incorrect answers, but I don't think that this means to be unfair. So the idea is that this tool can help you, but we are not declaring that for sure. For example, we can have no lawyers because the system can replace them. So the idea is that basically to facilitate the scanning process. But I would not say that this is unfair, not in the legal sense.
Sure, no, definitely not, but it could give someone a false impression
yes, sure.
of a clause or of
Sure, but the idea is then, for example, a legal expert should check whether the result is correct or not.
Can I ask a question about this? I think this central.
Yes, usually all the documents are double tagging, at least double tagging. Yeah, and then of course the tagging are compared, and then we come up with the final version of the documents. So we discuss each other, stating, okay, why did you mark this one as, let's say, a potentially unfair? I think that it's clearly unfair, and then we go more in depth. But more or less, for example, with regard to the terms of services, the agreement is around I think 89%. It is quite high. With the privacy policies are a little bit more complicated because of the way in which the clauses are phrased and can be sometimes interpreted in different ways. So the process is a little bit complicated.
But from what I understand of this project, then is like if the main apps that are being used are, let's say, 100 apps, then you have somehow 100 terms of service that will be the main ones that will cover already a lot of user cases.
Yeah.
So then if you somehow be sure that for these cases your system
Actually,
works well, or is manually annotated, because it's what you
yeah.
are annotating manually, so then when people are going to try your app, likely it's going to work because it will be the same cases. So
yeah.
I think for this project, from what I understand, is a very good project that can combine easily the manual annotation with
yes, of course.
with the automatic one.
Yes.
The manual annotation can easily cover the majority of your user cases from.
But you know, there are a lot of services, thousands and thousands of services. So it is true, but so actually we are sure about the data set, of course, that has been, as I told you, double tagged and also checked, for example, because we worked with regard to the privacy policy with data protection officers and consumers organizations to check whether all the documents were correctly labeled. But of course, the system can also give you results since it is able to predict the unfair clauses with documents that the system has never been.
Gives good results in this case.
Yes, around actually we are running experiment with increased data set with regard to the contract, the terms of services, but with 50 documents, the accuracy percentage is around the 89%. So it's quite, I think it's a good result.
Okay. Other questions? Okay. Just for finishing, we will propose a little exercise, something that no one's done, and we have some terms of service and privacy policies, and we will distribute it, and we can just say, let's try that if someone, according to the criteria, found a clause which is unfair or potentially unfair, just raise the hand and let's see. I mean, we have a couple of.
Thank you. No, ma figurati, quello non, tra l'altro, anzi, a Firenze, all'EUI, noi abbiamo questi gruppi settimanali più o meno, tematici, dove ogni settimana c'è qualcuno che presenta un paper che sta scrivendo, cioè quello che noi chiamiamo il metodo Oxford, cioè tu arrivi lì col tuo paper che dai in realtà una settimana prima, hai un discussant e poi chiunque se lo legge può intervenire ovviamente. E partono sempre le discussioni con paper meravigliosi, interessantissimo, fantastico, ma hai pensato che partono una valanga di critiche che in realtà sono un massacro, che però sono costruttive, quindi alla fine
Dal punto di vista ingegneristico, no? C'è sempre la cosa che stai facendo la tecnologia, quindi stai aiutando, però non si pensa magari a effetti negativi o cose del genere, quindi appunto gli approcci sono.
certo, diversi.
If you have any question, Francesca can answer. So.
È caldissimo. È caldissimo. Ma tu ti occupi? Ho visto tipo di musica AI o qualcosa del genere.
La mia tesi dovrebbe studiare i sistemi di raccomandazione musicale
Ok.
e come ci influenzano in parte nei nostri gusti musicali, in parte anche in come ascoltiamo la musica e scegliamo certe decisioni. Diciamo, parte di queste cose però molto prese sulla musica, che comunque diciamo che dallo streaming in poi è cambiato molto la nostra maniera di scegliere, di ascoltare, quindi mi interessa un po' seguire, soprattutto pensando sul discorso della diversità, ossia questi sistemi di raccomandazione ci chiudono, diciamo, nella nostra bolla dei gusti e ci aiutano un po' a esplorare.
A conoscere nuove.
Avrò la fortuna che lavoro i miei due supervisor sono lavora in questo centro di ricerca europea sugli impatti dell'intelligenza artificiale e l'altro ha studiato algoritmi in fairness, una vita, cioè proprio è un esperto di un sacco di cose, quindi sto facendo due.
Sei al secondo anno? Il primo.
6 mesi dopo. Sì, 6 mesi fa. Aurelio mi ha coinvolto a fare queste cose. Vabbè, in realtà si parla, cioè sono temi che poi riguardano un po' tutti i rami dell'ingegneria, però poi nessuno.
Sì, dai, io per esempio adesso sto scrivendo, tra l'altro adesso con un altro computer scientist di Bologna e stiamo aspettando che ci mandi il suo contributo, ma abbiamo fatto un articolo su AI e creatività, quindi l'uso dei sistemi di AI per la generazione invece, per esempio, no? Di musica, filmati.
Sul copyright.
Sì, esatto.
Quello è molto interessante perché pure c'è tanto nel nostro progetto devo essere in contatto di uno particolare che ha detto questo sistema con retrorali in cui basicamente crea nuove canzoni folk, ma neanche ne crea infinite e questo lui ha fatto uno studio molto bello perché prima ha fatto il sistema, poi l'ha messo quindi si è confrontato con i musicisti, poi da lì tutto hanno fatto un CD, quindi hanno visto un po' l'impatto con le persone, ha fatto praticamente un suo postdottorato su questa cosa e adesso insegna.
C'è un festival a Bologna molto bello che si chiama Future Film Festival, che fanno ogni anno, dove ci sono un sacco di applicazioni di intelligenza artificiale, per esempio sia nei videogame e di interazione con l'utente dove no, cambiano i plot, le storie, deviano ma anche per esempio sulla generazione musicale del suono a seconda per esempio delle espressioni facciali di chi sta guardando il video, sì, ce ne sono tantissime.
La cosa più, cioè come hai visto, quando non c'era quasi mai appare qualcuno che ti background, penso c'è anche la musica.
Certo.
È una cosa abbastanza rara perché c'è le cose che dici, cioè non ci penso, però poi alla fine tutta questa gente è quella che fa queste cose.
Certo.
Cioè siamo un po' tra di noi, diciamo. Okay, if someone detects an unfair clause, can raise an hand and just tell. Okay, the first one win. I don't know.
Don't be shy.
So. We went with case study 3. We chose the case study 3, the Airbnb privacy policy. After reading the Airbnb privacy policy on page 2, we marked it as retention 1 code because it didn't specify how long the ID documents could be retained by the party.
Okay, it is not a retention clause. Basically, because the idea is that the clause should state something about the retention. So in the contracts, for example, in the Airbnb privacy policies, you have clauses, for example, stating that we may retain your data as long as it is necessary. So for example, in this case, the clause, so the idea is that you can only, as I tried to explain you before, they can do whatever they want. But what we can do is only see whether in the clause there is something that they are stating. So, for example, in case of privacy policies, if an information is completely missing, so that the system was not able to recognize any kind of clauses related to the data retention, this basically means that they are not compliant because the information is completely missing. But if there is a clause stating, for example, that they retain your data as long as it is necessary, or, for example, this is, of course, an unfair clause, while, for instance, if the clause states that they retain your data as long as you have an active account, then, in this case, the criteria for determining how long they will have your data is specified. This basically means that allows you to identify the period, because whenever you cancel your account on the service, the data will be deleted. So this is the idea. This is the purpose of processing. The Airbnb privacy policy, the clause, is a clause related to the purpose of processing. Because it states that all the information are collected in order to verify your identity, provide a payment service to you, and to comply with the applicable law. So it's a fair clause with regard to the processing, because the idea is that, for example, they will need your national ID card for making a reservation for you. So, and the purpose is specified quite well with regard to the information collected. Otherwise, it would not be possible, for example, so you can decide whether or not to send it, but otherwise it could not be possible, for example, to make a reservation for you. It's an intermediary service, but then also when you, for example, if you make a reservation and go in the hotel, the first question is, can you give me your ID?
Yeah, but there they check it. They don't have to make a copy of it.
Usually, yes. They have a copy for security reasons. When you give them your ID, they usually, yeah, because they need to verify your identity. For instance, I don't know, with regard to the use of credit cards or whatever, I mean.
Okay, if someone else wants to detect a clause, unfair clause, if you have it. Okay.
It's actually the same clause, but we were looking at the Airbnb one, and at the end when it says, so it says such as in terms of examples, but it doesn't specify everything. So then we found maybe in the categories of personal data it says, yeah, so it will have to be when they only provide examples, because I guess then it
exactly
much more, right?
Yes,
okay.
This is true.
Anyone else? If not, then I think we can conclude here. Just last thing, as I said at the beginning, this kind of initiative, let's say, is a work in progress. So if you go to www.menti.com, you can enter the code and you can vote the thing that maybe you will like to do, let's say, next year from September on, and just explain the difference. I mean, this is a debate group, so basically to choose a topic and to review some literature and debate about it. A reading group, so just presenting a paper and one paper for session. Workshops, so maybe one day or half day with a series of seminars and inviting speakers, and seminars, events like this. And Fate and Beer, it's kind of short pitch, 10-minute speech about personal research or personal interest, and then having a beer all together. And yeah, you can just go there, put the code and vote, let's say, 2 options, your best top 2 options, and stop. Thanks.